Good morning. My name is Oliver Howell. This presentation is for Strategic International Transactions. I want to thank all of you for taking the time out of your holiday break to watch this video, as I wasn't able to be in class last Wednesday. I hope you're having a good break and not eating too much turkey. Today, I want to talk about international commercial arbitration. Generally, international commercial arbitration is the binding resolution of business disputes among or between transnational actors through the use of arbitrators rather than the courts. And we're going to talk about why multinational corporations from the U.S. Decide to use arbitrators as opposed to the courts. One of the reasons is that you're able to choose the judge. Arbitration is typically faster than litigation. It's cheaper. It's flexible for businesses in particular. It's non-public. And the entire arbitration system defers to the arbitration clause, by which when the parties contract together and form an agreement, they're able to choose the language of the arbitration clause rather than drawing upon a country's body of law, which obviously they're unable to author themselves. And then lastly, it's easier to enforce an arbitration award than a court judgment from a domestic court. So if you have a U.S. court judgment and you're the winning party, it'd be a lot more difficult to enforce that, say, in China than if you had an arbitration award. And we'll talk about why in a bit. Also, arbitration awards are very hard to overturn. There really isn't much room for appeal unless you meet a very specific criteria of appealable offenses, which is basically when the arbitrator messes up and goes outside of the scope of the arbitration clause. And one more thing before we get started. In the arbitration process, there's generally not much, if any at all, discovery process. So it's very different than litigation in the U.S. in particular. So we'll start with a quote from Ben Franklin, who we all know and love. He said, "When will mankind be convinced and agreed to settle their difficulties by arbitration?" So this is something that people from the U.S. have been thinking about for a long time. Just briefly, what we're going to talk about, we're going to go over the history of arbitration. We're going to talk about the forum and very different rule sets depending on what forum you go to. We're going to talk about which characteristics make arbitration more attractive than litigation. We're going to do a quick case study on China and Hong Kong. Just briefly, I'm very interested in those two regions. I lived in Hong Kong for about 11 months before law school, and I hope to someday get back there. Anyway, we're going to talk about what you need to have in the actual arbitration clause or agreement, and then we're going to talk a little bit about the U.S. jurisprudence with relation to arbitration and its enforcement. So, starting with the history, there's this concept called the Lex Mercatoria, which started in Roman times. But the first actual evidence of the Lex Mercatoria actually comes from the Middle Ages, so right after the fall of the Roman Empire. It's Latin for merchant law, and basically what it is it's a process similar to arbitration today, where disputes were resolved between merchants without government intervention and without going to the courts. The main Lex Mercatoria principles are efficiency, party autonomy, choice of arbitrator, and that the proceedings be confidential in nature. It offered merchants who did business between each other speed, which was very important because every second that clicked by that a dispute arose, money was flowing out of the pockets of the merchants. Typically at that time, courts were very, very slow, tended to be a little bit more partial than they are today. And so the Lex Mercatoria offered the merchants the ability to choose informal rules, choose judges based on their commercial background. So normally the judges were actually merchants themselves. And gradually this grew into informal, professional, private judiciary referred to as the lex mercatoria. Um, and as this developed, the world kind of fell in line with this system as well. There was an increase in international commerce, obviously, in the last century. National trade barriers were kind of broken down, and as we know from globalization 2.0, not 3.0, there is quite a lot of international trade going on today. So the most important uh, legal aspect of arbitration or change was the New York Convention in 1958, technically called the Convention on the Recognition of Enforcement of Foreign Arbitral Awards. This is the most important convention, because it gave all the parties to the convention, all the member nations that signed it, the power to enforce international commercial arbitration awards. And that's important because a contracting state, a party to this convention, shall be able to enforce an award that's obtained in any of the other countries. Um, so the winning party of an arbitration or a court judgment has to go to the country where the losing party keeps all of its assets, right, to get paid. And this is very typical. This typically is quite hard with just a domestic court judgment. But any party to the New York Convention, you can go to that country and have the arbitral award enforced. And as of 2014, 194 nations have signed the New York Convention. Um, so in 2008, I worked for a law firm in Los Angeles that actually also had a branch in Chengdu, China. And one of the senior partners, the founding partner there, told me the story where he moved there, tried to start a law firm, and couldn't get really many clients outside of U.S. businessmen that were doing business in China, and he kept having to fly back to the U.S. because the only place that they could enforce a contract or something like that was in U.S. federal court. But then he discovered that if you had a arbitration award from any court, typically then most parties were used the London system and rules and court. And if you had an arbitration award from them, the Chinese government would actually let you collect on the arbitration award. So he had many clients with U.S. federal court judgments that were out of luck because, a manufacturer sent them 5 crates, 20,000 TVs in them or something like that. And all of that company's assets were in China. Well, a U.S. federal court judgment doesn't mean much to the Chinese judicial system or court system. So he took up mostly arbitration cases for the period of 15 years and ended up making quite a bit of money because the Chinese court system uh, honors those arbitration awards. Anyway, back to the New York Convention. The other thing that the New York Convention did is it limited the defenses that you have when you are, or it limited the grounds that you would have to appeal an arbitration. And real quick, we'll go over those. So, to appeal an arbitration, you have to prove that there is legal incapacity of a party to bind itself to the arbitration agreement, or you have to prove the invalidity of the arbitration agreement under its governing law, so whatever rule of law that you chose in the arbitration agreement. You have to prove the procedural impropriety and unfairness of the proceedings, or prove that the arbitrator was outside of the scope of the arbitration agreement, or you can prove that the arbitral award has not yet become binding on the parties or has been suspended, dismissed, or otherwise by a competent authority in the seat of arbitration. Um, and then lastly, if the enforcement was contrary to public policy. That's a really, really difficult one to prove. So the New York Convention paved the way for a lot of multinational corporations to start using arbitration. Um, but the Federal Arbitration Act of 1925 is the law in the U.S. that requires when the parties have agreed to arbitration, so they have a binding or compulsory arbitration clause in the agreement, they must abide by that. They must do that arbitration in lieu of going to court. So this prevents people from binding themselves to arbitration and then at a later date when they lose saying, oh, I'm just going to sue you anyway. So the Federal Arbitration Act, or AAA, applies to both state and federal courts. And even if you have an arbitration clause that's binding in an agreement, you can't contract to expand the powers of those parties to appeal the arbitration. So even if the language is in the contract courts, U.S. courts, the U.S. Supreme Court has said that you can't expand on those powers beyond what the New York Convention says. A binding arbitration clause is a binding arbitration clause. So the takeaway from these two laws, or convention and law, is that U.S. federal courts will not set aside an arbitrator's award for mere errors of fact or law. Basically, only when an arbitrator goes beyond the scope of the arbitration agreement will U.S. courts tend to interfere. And obviously, that's a generalization, but that's probably the best takeaway. So now we're going to switch gears, and we're going to talk a little bit about the various forums and rules. So I've picked a couple of the main venues. I think I alluded to this before, but the main venue is in London. The American Arbitration Association has its headquarters and an international system of arbitration in New York. Hong Kong is a very popular place for those doing business in Taiwan, the People's Republic of China, and that area. Recently, Singapore has had a smaller arbitration court, and then there's a very new one in Switzerland that we'll talk about briefly. So, turning to London, the London Court of International Arbitration is the oldest and perhaps most respected arbitration court. Generally, people will refer to it as LCIA. It's been around since 1883, and it has its own rules that are often adopted by an arbitration agreement, used by arbitrators, mediators around the world, even if the LCIA isn't used. So its rules are very highly respected and carefully drafted. So when the LCIA is a party or is used, the LCIA court has the final authority for proper application. It appoints tribunals. It deals with challenges to arbitrators' authority, and it helps control and settle the costs of arbitration. And if you use the LCIA as opposed to a court, obviously, even through the appeal process there, everything is still kept private. So it'd be different than going through the arbitration process and then trying to challenge it in, say, federal court in the U.S. Okay, so turning to New York, the International Center for Dispute Resolution is from the American Arbitrators Association. I know if any of you have had Professor Bedikian, she used to work, she was, I think, district president or something like that of the AAA in Detroit for many years. So the International Center for Dispute Resolution was founded in 1996 by the AAA. And it's often used in the U.S., but they actually have 650 independent arbitrators or mediators all over the world and different offices all over the world. So the AAA doesn't itself arbitrate, but it provides administrative support, helps hook you up with trained arbitrators that they've approved, has its own rule set, and a lot of union cases are settled by AAA, just with its U.S. focus. Another example that the AAA was used is the Hurricane Sandy relief victims, if you may, were asked to settle most of their disputes through AAA. Actually, the AAA is one of the only courts that publicly posts their fees. So I just wanted to give you a quick example of how much it would cost. So if your claim amount, your dispute is worth 500,000 to 1 million, then the cost of arbitration on using the AAA system is 11,620. So, I mean, compared to using the legal system, the U.S. judicial system and lawyers, it is actually quite economical. Cool. So let's move to Hong Kong. The Hong Kong International Arbitration Center was established in 1985 by businesses and the government, but it's a nonprofit like the others, and it's completely independent of the government. And if you don't know, Hong Kong obviously is Western and a lot more democratic, or it was, than China. It was British for a long time and then released. So it's an international hub. It's a very cosmopolitan place. There are a ton of Europeans and Australians that live there, and it's very, very, very pro-business. So it makes sense that a lot of businesses that are conducting business in China would rather resolve their issues in Hong Kong as opposed to in Beijing or Shanghai. So Alibaba, which I know our class has talked a lot about, in all of their agreements with all of their suppliers and any of their contracts, requires binding arbitration, and they list the Hong Kong International Arbitration Center as the forum. So if you do business with Alibaba and it goes south, you'll end up in Hong Kong, which wouldn't be so bad. And yeah, like I said, Hong Kong is absolutely my favorite city in the world. So if you ever get a chance to go there, do it. And email me. I have lots of suggestions. So real quick, let's move to Singapore. There's the Singapore International Arbitration Center, established in 1991. This is pretty small. There's only 259 cases that heard there in 2013. But Singapore is a very controlled, clean, beautiful environment, actually. All of their buildings seem brand new. I could see why it would be an appealing place to do arbitration. And the interesting thing about Singapore is that forum uses a set of rules or model law developed by the UN. So the UN has a commission called the United Nations Commission on International Trade Law that organizes. You can be a member of this organization. They hold conventions all over the world. They develop model laws, guides, assistance, conduct research, and write reports about doing business in a certain country. And so they promulgated a set of rules that the Singapore court uses. And one thing to keep in mind with all of this is that one of the points of choosing your arbitration setting and arbitrators is that you want to choose one that is impartial to the parties. So like if you have a U.S. business and a Mexican business, you might choose to resolve your dispute in London, where the arbitrator, who you presume is British, doesn't share the nationality of either party. So that would be another reason why, say, you're from Hong Kong, you're doing business with the U.S., rather than using the Hong Kong arbitration court, you might go to Singapore, where the arbitrator would not share your nationality. I hope that makes sense. So lastly, in passing, we'll talk about Switzerland. There's a very new Swiss Chambers arbitration institution there, and this was actually set up by various Swiss, Chamber of Commerce organizations that banded together to set this up. Switzerland is generally looked at as a very neutral place. So I don't know about how business friendly it would be, but this is very small. There's only 276 awards in 2013. One interesting thing about the rule set in Switzerland is you can actually apply for emergency relief before you even go to the tribunal. So, in certain situations, you can imagine why that would be helpful. All right, so let's talk about the characteristics of arbitration that make it attractive. We've talked a little bit about this, but the International Chamber of Commerce identifies the following characteristics about arbitration as why you would choose it over the U.S. judicial system. First, the flexibility. So you're able to choose the arbitrator, choose to arbitrate or not in the first place. What kind of arbitration is going to take place, where it's going to take place, what body of law you're going to use, the number of arbitrators that you're going to use, or how you're going to select them. And then you can agree in advance to the amount of time that arbitration is going to take and how much it's going to cost. Secondly, neutrality is important. Like we just talked about, you can choose an arbitrator that doesn't favor one party over the other. And the selection of the arbitrators is a huge advantage over litigation, where you can't actually choose your judge. And this inspires confidence in the process. You can choose an arbitrator based on their business experience, their language ability to speak to your parties. And it is often said, I remember Professor Budikian always says, arbitration is only as good as the arbitrators. So you really want to make sure that you get a good panel or a good arbitrator. And then cost. It's very inexpensive compared to long, drawn-out appeals. Because of its finality, once you go to an arbitration, you're done. There's a limited scope for challenge that we talked about earlier, and that finality is actually cheap. And then there's the confidentiality aspect. A lot of companies don't want to publicize their disputes, and if they settle. So in a lot of ways, it's like a settlement in that regard. And then what we talked about earlier, the New York Convention is important, that you're able to enforce when foreign court judgments or domestic court judgments are unenforceable in certain situations. So turning back to Asia just for a second here, China and Hong Kong, there's this concept in Chinese culture called diumenzi, which means to lose face. And generally, the Chinese culture looks upon settlement as to lose face. So there's this tendency not to settle. So arbitration becomes attractive for a variety of reasons, but one of them is that it's binding and you don't have a choice in the matter, and so you don't lose face quite as much when you go to an arbitrator and they impose a binding final resolution on you, rather than trying to settle and look weak in their eyes. But it's also popular for these reasons in China and that area. There's no discovery in the Chinese court system. So if your arbitration allows for a little bit of that, not much, it's better than the Chinese court system. Chinese courts tend to have corruptible judges. I know that's a very broad generalization, but there is this concept of guanxi, which is to build relationships, and culturally, you take care of someone with the assumption that they'll take care of you. So gifts and bribes and granting judges types of favors is popular in Chinese culture. And, it's not necessarily looked on as bad as it is in Western culture. So there's that whole concept to navigate. There's no clear body of law. A lot of the laws and the PRC laws are very vaguely written on purpose, and that actually gives the Chinese judges a lot of discretion because of the vague laws. And obviously that tends to favor the government in any litigation. And then, in general, arbitration, you're able to choose the language and helps cross some of these cultural barriers. So it makes sense why U.S. businesses choose arbitration when doing business in China and Hong Kong. So the goal of arbitration in general, when you're drafting an arbitration clause, is to draft an agreement that if a dispute arises, it will help parties obtain an award without a detour through the court system. So it's important for the agreement to focus on these elements: enforceability, choice of law, the extent of court intervention, if any, the choice of procedural rules, like we talked about, the choice of language, the appointment of the arbitrator or arbitrators, the costs of arbitration, and the scope of arbitration, the arbitration clause. So that, I mean, that's generally the characteristics that you need to consider. And I've taken that from all of the rule sets that I've examined. And as long as you, when you're writing an arbitration clause, you follow those guidelines, so you should be in good, good shape. So we're running out of time here. We're gonna speed up a little bit. Just in closing, I wanted to talk a little bit about a concern that's come up recently with international arbitration is big data. So these companies, I mean, have tons and tons and tons of emails. And I know if any of you have taken e-discovery, going through those emails and documents and electronic big data submissions is very costly. And as U.S. federal court systems have tried to deal with e-discovery, it's made arbitration more attractive because without discovery, you save those huge discovery costs. Professor Katz said that 80% of all litigation costs are actually spent on discovery. So right now, arbitration is attractive when it doesn't have discovery, but because as big data increases in the corporate climate, it might be necessary to include more discovery in the arbitration process, which will make it less attractive in juxtaposition to the U.S. court system. So that is a concern, and there may be a tendency to go back towards the U.S. judicial system to resolve these type of disputes. All right, well, I hope I answered some of the questions. Thank you for your questions. To those 4 or 5 of you that emailed me some questions ahead of time. And thanks again for spending a couple minutes with me on your holiday break. And if after listening to all of this about international commercial arbitration, you have any questions, feel free to contact me at any time. My contact information is on the first slide. So thanks and have a great day.